Present. Caught injuries over the full right, caught injury extending below the right, left side. Rupture. Water. Hypovolemic shock arising out of the injury to the large vessel of nature of it is homicidal, however, and the query report is 19. I have examined the weapon of offense in the acts locally produced by the injury number 1. Caught injury just behind the right ear, so and so. The caught injury extending, so and so, right ear. Injury, caught injury. These injuries can be caused by acts. Opinion based on a positive opinion action. Market exhibit 19 ता पूर्व it has a PM so chapter injury injury number 1 caught injury in the right ear behind the right ear size so and so another caught injury below the right ear to the left side
all in face area put a skull fracture is skull fracture
so and this is
sufficient to cause death.
The injuries are found sufficient to cause death. This is written down. He is Mr. Kesichi. Map is exhibit 11. Fire.
It was it's 70. It's 70.
That's 71. Spot map. Human other systematic minority
Business 70.
G and Bahar village. Arts was left by D. Place Russia.
Dead body पकड़े detach करेगा.
Recovery of an arts was left behind on the place of dead body was C. Mr. Tripathi,
Yes, Milord.
though in the exhibit list it is mentioned that this particular document, postmortem report,
Yes.
which has been marked as exhibit 18, it is on admission, but we have gone through the order sheet. In fact, the State Defense Council objected and filed a memo that the accused will be seriously prejudiced if the doctor, PM doctor, is not examined. Many questions would have been put to the doctor. So it was not proper on the part of the judicial that trial court to write that it is marked on admission, because it was order sheet says something different than what has been mentioned in the.
Yes.
Number two, we find there is nothing that why the doctor was not examined. What is the reason? Cannot say that he is not a material witness.
Yes,
so he is one of the most material witness in a case under section 302. And the accused has a right also to put questions. And many cases you must find that if medical evidence is states something different than the oral evidence, case ends in acquittal. So order sheet at least doesn't indicate that any sincere attempt has been made to
examine the doctor.
Examine the doctor. Then that weapon has not been produced in court.
Yes.
Where is that? That has not been marked as an MO.
MO, yes, marked.
Which is that MO?
PW9, the IOS stated.
Please come to the MO list, Mr. at page 33. MO नील লেখা আছে जजमेंट रे अपन कोड पाइले one tangia was sent to the doctor.
That part is all right, but no MO.
But the witness.
Yes, my lord. That is page 66.
66. Let us see that.
Middle portion.
Just middle portion.
Yes. I received the PM report on 28/2/2007. I addressed a query to the concerned MO along with
MO means medical officer.
Yes. Yeah. I sent the weapon of assault for his examination and opinion and received a report in the affirmative.
That's a different matter.
That is the line. Exhibit 16 the query report 16/1 is my signature. On 5/3/2007 I produced the MO before the Honorable SDJ Malkangiri.
It's all right. It is to be produced during trial. The witness who has seen the occurrence, he should identify that this is the weapon.
That is not
right.
confirmed. Yes.
So it was kept in the Malkhana. It never seen the court.
So it should have been produced. So suppose let us say hypothetical we are telling, if that weapon would have been produced, you say that you seized it from the spot. The witness would say, no, this is not the weapon.
Yes.
So what would happen? So these are the gaps. What we are pointing out, that these are the gaps, and you sent it for C examination. So where is the C report?
That is not there.
So.
Yeah, but there was no bloodstain in the axe also. Nothing reveals that there was bloodstain in the axe. But who is the seizure witness examined in this case? PW
7 and
4 and 7.
7.
4 is not very vital. He has only
7 is vital.
7. Jagannath Naik, co-villager.
Prosecution should have taken steps when you have sent the material objects and other exhibits for C report. It is your duty in a case under section 302. You are sentencing somebody to life imprisonment. It is your duty not only to procure those objects, right? It has gone for examination whether any bloodstain is available or not. If so, what is the group, etc.
Yes.
So you are not producing the C report, not producing the weapons, and that also, once the weapon would have been produced, it was the duty of the public prosecutor or additional public prosecutor conducting to confront it to the at least the eyewitness and the seizure witness,
Yes.
and the also the IO that a particular weapon ta
Yes.
spot re ye thila, ei weapon ta use heithila assault pai, ସେଟା କିଏ କହିଥାନ୍ତା? ଯୋ ଆଇ ୱିଟନେସ୍
Eyewitness.
ଦେଖିଥିଲେ ତାକୁ କହିଥାନ୍ତା। ତ ଆପଣ ଏଗୁଡାକ ଲ୍ୟାକିଂ କରୁଛି, and obviously the State Defense Council has not put any question.
No denied. That is the only thing is that
Yes,
they have
sir.
not denied the nature of death of the deceased. No question has been put to the eyewitness to that effect also. No suggestion is also there.
ଆଉ କୌଣସି ସାକ୍ଷୀ ଘଟଣା ବିଷୟରେ କହିନାହାନ୍ତି?
No.
What about the evidence of the that informant?
PW5. The wife of that.
ପଢିଲେ ଟିକେ PW5 ପଢି।
I know the accused person standing in the dock. One of them is my father-in-law, and the other is the elder brother of my deceased husband. The incident took place about 10 months back during summer. On the date of occurrence, I was in the vegetable garden situated on the bank of a stream near our village. My deceased husband and son were coming to meet me. At that point of time, my husband was killed. Immediately after the occurrence, my son ran to me and told me that as they were coming on the way, my father-in-law and my husband's elder brother were laying in wait, and Ramachandra Noli, my husband's elder brother, gave a blow on the neck of my deceased husband by means of a tangia, and my husband fell down. My father-in-law was also standing there. Out of fear, my son ran away from the spot. My son also told that Ramachandra also tried to kill him, my son. Thereafter, I, along with my son, rushed to the village and intimidated the villagers. The villagers accompanied me to the spot, and on reaching the spot, I found my husband lying dead on the ground with bleeding neck injuries. Thereafter, I went to the PS, and as per my telling, the FIR was drafted. It was read over and explained to me. After knowing the contents to be true, I put my LTI on the same. Police visited our village and examined me in connection with the case. Then cross-examination.
PW7 it goes on the list. PW7 witness to 27.
cross-examination ଟା ପଢିଦିଅନ୍ତୁ।
My lord.
କିଛି ତ ନାହିଁ।
It is not a fact that I have not stated before the police that I was in the vegetable garden alone, and at that point of time my son came to me and told me that my husband's elder brother and my father-in-law conjointly had killed my deceased husband by means of a tangia. My husband had land dispute with Narasingha Nali, who is the son of elder brother of my father-in-law. On the previous day of the incident, Narasingha Nali had accused my deceased husband that he is selling away the lands on his own, and if he, my deceased husband, does not stop doing so, he will kill him. My father-in-law, my mother-in-law is dead. My husband's elder brother is issueless, and his wife is separate from him since long. My son and my daughter, they are to inherit the whole property. My father-in-law is fond of my son.
He's fond of my
Fond of my son. The spot is situated at a distance of 2 kilometers from my village. Immediately after the occurrence, I went to the village, intimated the villagers, and we arrived at the spot about 3 to 4 hours of the occurrence. It is not a fact that my father-in-law and the elder brother of my deceased husband did not kill my husband. The FIR was drafted as per my narration.
It has been brought out in the cross-examination. Except that part, he was not there in the
spot.
garden re seti nathila na spot re to se kouni thila se garden ne thila seti bele ye asi taku kahila je emti bapa ku attack heichi boli.
It is not a problem.
Police pakare seta prove heichi. The investigating officer is PW 9.
Yes.
Nothing is there.
No. Cross-examination kichi nai takar.
PW 9 re eta apanakar jodi it's not a fact apana suggestion dele, it should be proved through the investigating officer that ପ୍ରକୃତରେ କିଛି କହି ନଥିଲା ବୋଲି ଏସବୁ ବିଷୟରେ। Mandate 45 Evidence Act, it is part you have performed. That means only you have said that you have not stated like that. He said, no, I have stated. So it's not a fact. Whether he has stated in fact or not, that is to be proved by the investigating officer who has recorded that statement. So when the IO comes, this question should have been put that a loko 7 number sakhi, sorry 5 number sakhi ଆପଣ ପାଖରେ ଏମିତି କିଛି କହି ନଥିଲା, ସିଏ ଦେଖିକିନି ଭେରିଫାଏ କରି କହିଥାନ୍ତା, ତାହେଲେ ସେଟା ଏଟା ଅଧାରୁ ରହିଗଲା। On the previous day when Nursing Mali had accused my deceased husband. Nursing Nali ଆଉ ଏଇ ଯୋଉ appellant ଭିତରେ କଣ relation କଣ? ତାର land dispute ଥିଲା, my husband had land dispute with Nursing Mali, who is the son of
related
elder brother, grandfather related, ବାପା
ମାନେ ଶ୍ୱଶୁରଙ୍କର ବଡ ଭାଇ ହେଲେ
ବଡ ବାପା ପୁଅ ସେ।
On the previous day incident, Narsinga accused Swanson.
Elder son of my grandfather.
So nursing is not in picture here.
So prior to the incident, there is no quarrel, nothing of that sort. Rather, the evidence indicates that as if you are, you have already prepared. That means the appellant had prepared and waiting for the deceased to come, and the moment he came, he started assaulting, that too on the vital part of the body.
But reason is not there. କୋଉ କାରଣ ପାଇଁ ସିଏ
ନା,
ମାରିଲା
ସେଇଟା motive is
ତ
always
once
not
the
there.
once
The direct
eyewitness
evidence,
is there,
the direct evidence.
direct evidence asile motive ro kon hi darkar. That assumes importance in case of circumstantial evidence. Joti eyewitness achanti seti there are number of decision to that effect, that when eyewitnesses are there, motives so
Insignificant.
So eyewitness is a minor boy.
No, minor. Minor in the
Just
sense,
14
he is
to
not
15
child.
years.
He is minor, 15 years.
15 years.
15 years.
Quite able to. Nothing of that sort.
This boy has also stated that I went and narrated everything to my mother.
Yes, immediately.
And mother also corroborates. And you just made out something in the cross examination. The police pakhre tame kahi nathilo je tamo puo asikini kahila boli. That has not been proved. So immediate registry of this
Yes.
witness PW6 in approaching the mother and telling what has been done to the father by this appellant. That's a relevant piece of evidence.
Registry is there. Section 6 will come into play.
And report is there. Of course, the doctor has not been examined, but
That is also not denied, sir. Otherwise, inquest report is there.
The part of the body which that witness is saying that these are the parts on which the assault was made, that gets corroboration from the PM report. ଆପଣଙ୍କର PM report ର ଯୋଉ injury ଗୁଡାକ ରହିଛି, cut injury, right ear, ତାପରେ ଆପଣଙ୍କର ଆଉ ଗୋଟେ neck portion ରେ ଗୋଟେ ରହୁଛି, ହାତରେ ରହୁଛି, left shoulder, left arm ରେ ସେଗୁଡାକ
Witness to the inquest, which reveals the immediate cause of death, has not been cross-examined that way. Details of the nature of injuries are found there.
There is no challenge to the evidence of the eyewitness that it's not a case of homicidal death.
Yes.
And this IO, he immediately reaching the spot, and the deceased was at that point of time lying at the spot itself with cut injury. The IO stated in page number 60, IO's evidence PW7. So PW7 ta IO mein, PW7 PW9. No, PW7 another. On reaching at the spot, I found the deceased had cut injury on the right side, back, neck. So we lost the information. Tapre
He was witness to inquest.
Inquest.
He was also in.
And that weapon was recovered. Say spot to jota
Yes, he
mila.
was the witness to the 27 evidence.
That will be the proceedings.
27 it would not be there because we verified from the spot map that it was lying adjacent to that dead body.
Yes.
So it was accessible to all. ସମସ୍ତେ ଦେଖୁଥିବେ ସେତେବେଳକୁ already IO spot କୁ ଆସିଲାଣି, ଲୋକମାନେ spot କୁ ଆସିଲାଣି, weapon ଟା ସେଇଠି ପଡିଛି, ତେଣୁ ଏଇଟା ଗୋଟେ this has been
Aspect that we never speak. That we try to find out the weapon of offense. We did not find it. That never comes from any evidence. All along they make it at 27, even if it is available on the spot.
So
we may not take that
so
one.
27 this evidence goes, it is not because of the
that-
place where the dead
Yes.
body has and the weapon, it was lying very close to.
And that is again not a matter of dispute.
Because the information was given by the son, okay, to the mother. So villagers came to the spot. That has been stated by this 7 and 8 also.
Yes.
That we reached at the spot, we found the dead body there lying with the injuries. All these things they have stated, and inquest was also held there. And IO has specifically mentioned in the spot map that what are the points A, B, C ହେଇକି ନି ସେ ଦେଖଉଛି ଯେ those
Tangia was
lying almost
close to the
close
dead
to the dead body.
Yes.
So ଏଠି ଆଉ accessible ଆଉ ମାନେ ଇଏ ନାହିଁ ନା, so it is open place, accessible to all. So ଏଇଟା ଗୋଟେ just make out କରିବା ପାଇଁ ଗୋଟେ additional ଇଏରେ ସେଇଟାକୁ this on the spot he died.
Instantaneous.
Coma due to shock arising out of neck, जो large vessel neck रो सेठी ଦେଇଛି जो छोटटा से उडाकर ता death କରିଛି. There is nothing we found to bring it within the purview of 304 part 1 or part 2 in spite of
କିଛି ଦିଟା ଟାଙ୍ଗିଆ ଶୋ କରୁଛନ୍ତି, ଦୁଇଟା ଟାଙ୍ଗିଆ ଶୋ କରୁଛନ୍ତି.
ଦୁଇଟା ଟାଙ୍ଗିଆ ମାନେ
ସେଥିରେ ଦେଖୁଛି weapon of assault namely Tangia gave recovery of the same from near the river bank. As per the
ସେଇଟା ହିଁ 27 କୁ ସେ କହୁଛି.
27 we
are not discarding that.
Yes,
we are not relying on that. 27 is discarded, but how do you get over this
yes.
eyewitness account?
On the same day, police effected a seizure of the another Tangia from near the dead body.
That might be another one, but not the one with which the
weapon of offense, let us say that that was not recovered at the instance of the appellant, but it was lying close to the dead body. It's all right, but 27, let us say 27 who discard for the IGO. But how do you get over this evidence of the eyewitness who is the son of the deceased and postmortem report finding?
and even the post occurrence witnesses consistency is there.
Yes, ma'am.
Reserve itself.
Yes, Mr.
Yes, sir.
କିଛି କହିବେ?
ନା.
Kitchen.
JCRL number 42 of 2008. The appellant Ramchandra Nali along with Dhanna Mali faced trial in the court of ad hoc additional session judge FTC Malkangiri in criminal trial number 30 of 2007. for offences punishable under section 302 by 34 of the Indian Penal Code. And these are 302 by 34 again. So far as co-accused Dhanan Ali is concerned, he was also charged under section 302 by reduced section 109 of the Indian Penal Code, 302 by 34 in the Indian Penal Code, on the accusation that on 24/2/2007 at about 7 p.m. in furtherance of their common intention, they committed murder of one Tulasi Nali, bracketary hereafter the deceased. The co-accused so is additionally charged under section 302 reduced section 109 of the Indian Penal Code, and the ground that on the accusation that he abated the appellant Ramchandra Nari for commission of the offence. The Lenin Trial Court, by judgment and order dated 31/2008, though acquitted the co-accused Dhanan Ali of the charges under section 302, 109, 34 of the Indian Penal Code, but found the appellant guilty under section 302 of the Indian Penal Code and sentenced him to undergo imprisonment for life and to pay a fine of rupees 5,000, in default to undergo RI for 6 months. The prosecution case, as per the first information report lodged by Kusuma Nali, bracketary PW5, the widow of the deceased, on 25/2/2007, before the before the inspector in charge of Mathili police station, that on 24/2/2007 evening at about 7 o'clock, while the deceased along with their son Sahadev Nali, bracketary PW6, were proceeding to tomato field, which is situated near the river, village river. At that time, the appellant Ramchandra Mali and the co-accused Dhanan Ali were waiting for their arrival on the way, and the moment the deceased reached near the tomato field, the appellant assaulted him by means of a tangia, as a result of which the deceased died at the spot. On the basis of the written report presented by PW5, Mathili PS case number 13 dated 25/2/2007 was registered under section 302 by 34 of the Indian Penal Code. And PW9 Aniruddha Rautray, SI of police attached to the said police station, took up investigation of the case During course of investigation, he examined the informant bracket PW5 and other witnesses, visited the spot and prepared the spot map Exhibit 11, and on the same day, that is on 25/2/2007, he seized sample and blotched earth and prepared seizure list in presence of seizure list bracket like to Exhibit 6 in presence of the witnesses. And at about 10:30 a.m., he seized one axe near the spot as per seizure list Exhibit 9. And he held inquest over the dead body and prepared inquest report Exhibit 1 and dispatched the dead body for autopsy. And on the same day, also he arrested the appellant, and at about 3:30 p.m. and at the instance of the appellant, on the basis of his statement, the axe was recovered. The statement recorded under Section 27 of the Evidence Act, the axe was recovered. The wearing apparels of the appellant are also seized as per seizure list Exhibit 7, and the co-accused Dhanamali was also arrested, and his wearing apparels were seized as per seizure list Exhibit 8. And both the accused were sent to the medical officer CSC Mathili for collection of nail clippings and saliva. And after collection of the same, those were seized, and the accused persons were forwarded to court of Learned SDGM Malkangiri on 26/2/2007. The postmortem was conducted by the Assistant Surgeon, Chest Hospital, Mathili Malkangiri on 26/2/2007. And the wearing apparels of the deceased after postmortem examination were produced by the constable who had escorted the dead body for the said purpose as per seizure list Exhibit 5. And the IO received the postmortem report on 27/2/2007, and he made a query to the concerned medical officer, sending the weapon of offense for his examination and opinion, and received a report in affirmative. The material objects were produced before the Learned SDGM Malkangiri on 5/3/2007 by the investigating officer with a prayer to send the same to RFSL Barampur. And on completion of investigation, charge sheet was submitted against the appellant as well as co-accused Dhanan Ali under Section 302(109)/34 of the Indian Penal Code. After submission of charge sheet, the following due procedure, the case was committed to the Court of Session, where the charges were framed as aforesaid. During course of trial, the prosecution examined 9 witnesses. সেটার দিকে দেখি শর্ট করে লিখে দেবে। The prosecution also exhibited 19 documents. সেটা বিজিকে লিখে দেবে। The defense plea of the appellant is one of denial. The learned trial court, after assessing the oral as well as documentary evidence on record, came to hold that as per the post-mortem report, the deceased died of homicidal death and account of Tangia blow. The learned trial court relied on the evidence of PW6 and found his version to be trustworthy and to be inspiring confidence of the court. The learned trial court also relied upon the leading to discovery of the weapon of offense at the instance of the appellant under section 27 of the Evidence Act. And after going through the opinion given by the medical officer examining the weapon of offense, came to hold that the appellant is the author of the offense, and it was he who killed the deceased by means of Tangia. The learned trial court, however, held that though the prosecution evidence is that the co-accused Dhanan Ali was present at the spot unarmed, but he did not take part in the assault in any way. And there is nothing on record to show that he had preconcert of or meeting of mind. There was preconcert or meeting of mind between the appellant and the co-accused prior to the occurrence, and accordingly acquitted the co-accused Dhanan Ali of all the charges. This is the item number 27. So you are Mr. Das, na? Sanjit Kumar Das? Okay. Mr. Sanjit Kumar Das, Land Council, appearing for the appellant, contended that the evidence of the solitary eyewitness PW6, who is the son of the deceased, is not clear, cogent, trustworthy, and therefore the learned trial has committed illegality in placing reliance on his evidence, particularly when he is an interested witness. It is argued that there was no motive behind the commission of the crime proved by the prosecution, and the spot map indicates that the weapon of offense, that is Tangia was lying near the dead body in an open place accessible to all. And by the time the police reached at the spot, the witnesses had arrived at the scene of occurrence, and therefore the prosecution evidence that the axe was recovered at the instance of the appellant basing on his statement is not acceptable. The Land Council further argued that though in the exhibit list of the London Trial Court it is mentioned that the post-mortem report has been marked as exhibit 18 on admission on 24 से डेट टा कहते कहते ওটা তারিখ 24 না कहते আমি দেখতে পেলাম 24 24/1/2008 hala. But the order sheet would indicate that the London State Defense Council in fact objected to the marking of the post-mortem report as an exhibit and further indicated that the accused will be seriously prejudiced if the doctor is not examined.
No.
He is not examined. The London Council further argued that the material object, that is the weapon of offense, was not produced at the time of trial to be proved in accordance with law, and though the material objects were sent for chemical examination, but the chemical examination report has also not been obtained to be proved, which has resulted in causing serious prejudice to the appellant, and therefore it's a fit case where benefit of doubt should be extended in favor of the appellant. Mr. Tripathi, London Additional Standing Counsel, on the other hand, supported the impugned judgment and submitted that the London Trial Court has rightly placed reliance on the son of the deceased, was examined as PW6 and narrated how the deceased was assaulted by the appellant by means of tangia repeatedly on different vital parts of the body, which resulted in instantaneous death of the deceased. And nothing has been brought out in the cross-examination to demolish the evidence of PW6. It is further argued that the post-mortem report indicates the nature of injuries sustained by the deceased, and the cause of death has been specifically mentioned to be due to coma on account of hypovolemic shock arising out of injury to the large vessel of the neck, and it was a homicidal in nature. And the weapon seized was also produced before the medical officer, who on examination of the same gave his opinion that the injuries are possible by the weapon produced. The Land Council submits that in a case where the evidence of eyewitness is clinching trustworthy merely because the prosecution has not proved the motive behind the commission of the crime, that would not be a factor to disbelieve the prosecution case, and therefore the appeal should be dismissed. Coming to the adverting to the contention raised by the Land Council for the respective parties, before proceeding to analyze the evidence of the solitary eyewitness PW6, it is necessary to find out whether the prosecution has successfully established that the deceased has made homicidal death or not. It is correct that the doctor who conducted the post-mortem examination and submitted the report, Exhibit 18, was not examined in the during trial, and it is also a fact that the London Defense Counsel raised objection to the non-examination of the doctor and marking of the post-mortem report as an exhibit, and in spite of that, the report has been marked as an admission. But we find that the defense has never disputed that the deceased has met with homicidal death. The postmortem report, the evidence on record clearly indicates that after holding the inquest over the dead body, where the details of the injuries have been noticed in the presence of the witnesses, the dead body was sent for post-mortem examination. And the post-mortem report marked as Exhibit 18 indicates the following injuries. Item number external injury ଅଛି so and so to ଲେଖିଦେବେ ସେଟାକୁ. It further indicates that there was a more detailed description of the injury ରହିଛି so and so ସେଟା ଲେଖିବେ. The cause of death has been opined to be coma due to hypovolemic shock arising out of the injury of the large vessel of the neck, and the nature of death has been found to be homicidal, and when the evidence regarding the nature of death to be homicidal has not been challenged by the defense, and in view of the inquest report, the post-mortem report findings, we are of the view that the London trial court has rightly came to the conclusion that the prosecution has successfully established that the deceased met with homicidal death. The evidence of PW6, who is none else than the son of the deceased as well as the informant, has been relied upon by the London trial court for finding the appellant guilty. The PW6 has stated that on the occurrence day, while he along with his deceased father were crossing, we are proceeding to their vegetable garden situated on the banks of the stream. On the way, he found both the accused person standing, and specifically stated that the appellant Ramchandra Nali was the elder brother of his deceased father, and the co-accused Dhana Nali was his grandfather. He further stated that while they were crossing the place where the accused persons were standing, the appellant attacked his father with a tangia and gave blows on the head, backside of the neck, right side shoulder, as a result of which his father fell down on the ground. He further stated that seeing this assault, when he asked the appellant as to why he killed his father, the appellant threatened him with dire consequences, and out of fear, he ran away from the spot. And the appellant also chased him for about 1 kilometer, and then PW6 reached near his mother and narrated the incident before mother bracket according to PW5 and narrated the incident before her. The witness has further stated that when they rushed to the village and intimated the villagers, and the villagers came to the spot. In the cross-examination, it is the witness has stated that when they set out for the vegetable garden, it was around 6 o'clock in the evening, and at the spot, his grandfather, he had never any quarrel with the co-accused Dhanam Ali, who was the grandfather, and he further stated that the ancestral property has been divided, and Narsingh Nali was the son of the elder brother of the grandfather, was aggrieved because his uh, deceased father had sold away portion of the land, and there was dispute between them. Nothing has been brought out in the cross-examination to disbelieve the evidence of PW6, and it has almost remained unchallenged. No doubt, PW6 is the son of the deceased, and but merely because he is related to the deceased, he cannot be labeled as an interested witness, or on that score, his evidence cannot be discarded. And a related witness is not necessarily to implicate falsely any person leaving the real culprit. The evidence adduced by the PW6 regarding the parts of the body where the assault was made by the appellant with a tangia is getting corroboration not only from the postmortem report, Exhibit 18, but when the weapon of offense was examined by the doctor, the as per the query made by the investigating officer, the doctor has also gave his views that the injuries are possible by the weapon. Neither the spot where the occurrence has taken place is challenged, nor the nature of death is challenged. Therefore, we find that the evidence of PW6 is clear, cogent, trustworthy, and absolutely reliable. Law is well settled that conviction can be sustained on the basis of the evidence of a solitary witness if he comes within such category. The PW6 immediately after the occurrence rushed to his mother and narrated the incident, and PW5 bracket PW5 कर देंगे. And PW5 has also corroborated the version of PW6 and stated that after the occurrence, PW6 ran to him and told her that while they were coming, while he and the deceased were coming, on the way, the appellant and the co-accused were there, and the appellant gave blow on the neck of the deceased by means of a tangia, for which the deceased fell down on the ground. And out of fear, he ran away from the spot. This conduct of PW6 in immediately reporting before his mother, PW5, is admissible as res gesti under Section 6 of the Evidence Act. The witnesses like PW7 and PW8 have stated that PW7 stated that when it was reported to him by PW6 that the deceased had been killed by the appellant by means of tangia, he along with the other villagers came to the spot, which is a place called as Jirumunda and adjacent to stream. And on reaching at the spot, they found the deceased had caught injury on the right side back of the neck. The PW8 has also stated that on the date of occurrence, the PW6 came and reported to him that the appellant had killed the deceased with a tangia. Therefore, there is sufficient corroboration to the evidence of PW6, not only from the post-mortem report findings, but also from the evidence of PW5, PW7, and PW8, before whom he disclosed about the occurrence immediately after the occurrence, he disclosed before them. The investigating officer has stated that when he visited the spot and prepared the spot map, bracket लिख दें तो exhibit 11, he visited the spot and he prepared the spot map, exhibit 11. The spot map clearly indicates that the axe was lying nearer to the dead body in an open place. The IO also held inquest over the dead body at the spot and prepared the inquest report, exhibit 1. Prior to which was done on 25 to 2007. When the co-villagers as well as the PW5 and 6 after the occurrence visited came to the spot, and on the next day the IO also visited the spot. It sounds improbable that the weapon of offense which was lying nearer the dead body would have gone unnoticed to everybody, close to the dead body, would have gone unnoticed to everybody. Therefore, the statement of the investigating officer that when he arrested the appellant at 4:05 p.m. on 25 to 2007, he made the confessional statement and gave recovery of the weapon of offense is not acceptable. And therefore, we are of the view that the London trial court was not justified in using this piece of evidence against the appellant. The weapon was seized from the spot and it was sent to the doctor for his opinion regarding possibility of injury noticed on the deceased with such weapon, and thereafter it was sent for chemical examination, which would be evident from the forwarding report marked as Exhibit 17. However, for the best reason known to the prosecution, the chemical examination report was not obtained and proved during trial, and even the prosecution didn't bother to prove the weapon of offense as a material object during trial. It was the duty of the prosecution in a case where the accused is facing trial under Section 302 of the Indian Penal Code to produce the chemical examination report, so also the material objects, and proved it in accordance with law through the competent witnesses. This is a lacuna on the part of the prosecution, and it can be said that the public prosecutor was somehow rather negligent in his was not was negligent in bringing those evidence on record. However, even if those evidence have not been brought on record, but in view of the evidence adduced by the solitary eyewitness (PW6) and the post-mortem report, the opinion report, and the manner in which the assault has been made on the deceased on different vital parts of the body, and the fact that as per the opinion given by the doctors, the injuries are sufficient in ordinary course of nature to cause sufficient in ordinary course of nature to cause death. And there is nothing on record to show that the occurrence took place on account of any sudden quarrel. And the looking at the surrounding circumstances, when the appellant was waiting with a weapon and for the arrival of the deceased, and the moment he arrived at the scene of occurrence, he was assaulted, and as many as 4 injuries were caused, including on the vital part of the body like neck, and which resulted in causing coma and hypovolemic shock, and causing the part of the large vessel of the neck, resulting in coma and hypovolemic shock. We are of the view that there is nothing to bring the case to any of the exceptions provided under Section 300 of the Indian Penal Code. And in view of the available materials on record, we are of the view that the Lennon Trial Court has rightly found the appellant guilty under Section 302 of the Indian Penal Code, and accordingly, the impugn judgment stands confirmed, and the jail criminal appeal stands dismissed.
The 2 aspects in this case, which has been dictated by my senior brother, with regard to the lacking in the investigation or on the part of the prosecution, is more in the academic side, not fatal to the prosecution case that way. One aspect is very important, which we'll also highlight, is the opinion evidence of the doctor has been taken to evidence under Section 45 of the Evidence Act, where certain documents, though it is opinionative, cannot be marked as exhibit unless proved by the doctor himself. So the contents doesn't go, even though the document in itself has been marked as exhibit. Had it been so, in absence of the doctor also, this PM report could have been marked everywhere. It is not marked. It needs to be proved. But having regard to the nature of evidence adduced by the eyewitness account, coupled with the inquest report and others evidence with regard to the homicidal nature of death, this lacuna will stand only academic. All right.
Yes. Yes. That is.
साढ़े 8ଟା କହିଥିଲେ ତ ସେ କାଉନସିଲ ନାହାନ୍ତି ଆସି ସାଢେ ଆଉଟ ଦେଖିଦେବା
ଆଉ ଗୋଟେ ତାହେଲେ ଆରମ୍ଭ କରିବା।
26ଟାରେ ଅଛନ୍ତି
Yes.
I'm sorry, my lord. About the elder penal Another courts I'm
No,
sorry.
you argue the matter. There is no problem.
On last occasion, the accused has been released on the bail on as per the government's order. The Lordship has directed for the State Council to obtain instruction regarding
So
that.
premature release.
Yeah.
What is the written instructions on to receive one? Yes, what is your instruction? Available.
Not
So, and the conviction remains. Sir.
as it is.
So,
The only evidence. Is the only evidence.
how is the only evidence? So, better you place it, the evidence we decide it, and hmm?
I want
Day थी यही रिलीज ହେଇଛି ଡେଟ୍ जो ଦିଆହେଇନି
ଏଠି ଅଛି ଆମର ରିପୋର୍ଟଟା ଦେଇଥିଲେ ସବୁ
27/2/2022 ହଁ ଏବେ
ମାନେ ପାରିବେ to wait.
premature released by the Circle Jail Baripada as per the order of the government order ଟା ହେଇଛି 26/22 ରେ
27 ରିଲିଜ ହେଇଛି
ହଁ 27 ରେ release ହେଇଛି
ରିପୋର୍ଟ ଇଜ ନଟ୍ sufficient.
Mr. Tripathi,
Yes.
this report is submitted by the IIC.
Yes.
He was released only on last year, and his family members, you say that he has left the families secretly staying somewhere. So suppose he's dead, let us say, for example. So now what will happen? Unnecessarily exercise would be there.
How could we ascertain that he is dead or
No, that is why you are giving a report that he is probably staying elsewhere secretly.
we are made
after
inquiry?
Now you have to make an inquiry. You can't just say that the ward member said this or he said this.
ଆପଣଙ୍କର report ଟା ascertain କରିଛନ୍ତି local ସରପଞ୍ଚ ଠୁ ଆଉ ୱାର୍ଡ ମେମ୍ବର ଆଉ କିଛି ଭିଲେଜ
villager.
ହଁ ଏମାନଙ୍କଠୁ ପଚାରିକିନି ବା ଲେଖିଛନ୍ତି confidential
And there is
inquiry.
no point in confidential inquiry. Why a confidential inquiry? He
The-
is a person who has been released.
Suppose his whereabouts is not known person, so there are other way out to find him. Your efforts.
Other efforts in that.
So what would happen in a case, suppose he has been released prematurely. Thereafter his case is decided and ultimately he is found guilty under section 302
Yes.
and sentenced to life imprisonment. Because the state government has released him pending
Yes.
disposal of the appeal. Now, is there anything that whether he will be again taken into custody to serve the remaining part, or that order which is there, release order, will still prevail over our decision, because we confirmed it and sent him to
Yes.
life imprisonment. So no doubt you have a power vested that to for remission is there, and it has been done. Also, it can be utilized during pendency of the appeal. There are decisions out there. But what would happen in a case where, let us say, for the appellant is stressed out and let us say he's interested.
Yes.
Hypothetically we are putting. He said that I will proceed with the case. Okay, and the appeal is argued, and ultimately it is dismissed. The appeal is dismissed. Life imprisonment sentence is confirmed. So you have released him prematurely. What will happen?
In that case, will be taken commutation will be there. Government will come in.
So no,
Coming back
again, and thereafter again you may utilize or that order. We don't think that will remain as such, because if it would have been done after the appeal is disposed of, matter is different. But during pendency of the appeal, if it has been done, so
In any case, his presence is a must.
that part also you examine, and we are also giving you further time um, to trace out the whereabouts of the appellant. You also examine on this particular aspect. He has been released prematurely. Suppose the appeal is dismissed. Tomorrow, let us see is traced out, and he says that let my appeal be heard on merit, because ultimately the conviction will remain, and the appeal is heard, and we confirm. Let us say hypothetically, then what will happen?
I'll examine, ma'am.
Okay.
Now, in one case, your lordship were directed the legal service authority to advertise notice in the newspaper regarding this.
No, here why should we go for that? Police is there, investigating agencies are there. Let them do it.
Yes.
Let them do it. And here, we may also confront with another question, as it normally happens when a case gets abated on the death of the appellant. The kith and kin of the convicted, they can take up the matter. In that case, because it's a stigma. So in order to get rid of the stigma, they may pursue the matter. So here is the case. Now, unless we are very much sure that the appellant is no more in this world, then only we can proceed. So we'll again impress upon
That is
to proceed.
394.
Yes, sir.
Every other appeal, every other appeal under this chapter, except an appeal from the sentence of fine, shall finally abate on the death of the appellant. So, but provided that if it is in conviction and sentence of death or so, the appellant dies during the pendency of the appeal, any of his near relatives may within sworn to this. So that will lead. No, that's he's they are not able to get the confirmation. As per the order dated 6/10/2023, the Learned Council for the state has produced the report dated 12/10/2023 of the Inspector in charge of Sadar Police Station, Baripada, wherein it is mentioned that after being released from judicial custody, the appellant has disappeared and did not return back to his village, Besar Pani, under Baripada Sadar Police Station jurisdiction, for which his present whereabouts is not known to anybody. It is further mentioned that the appellant is probably staying elsewhere secretly after leaving his family and native place forever, as ascertained from local Sarpanch Mali Mohanta, ward member Daitari Bhakta, and other village entries during local and confidential inquiry. And effective efforts were also made to contact the appellant and to reach his present location, but all the efforts proved futile. The Land Council after going through the report furnished by the IIC Sadar Police Station, we are not satisfied that proper attempts have been made to know the whereabouts of the appellant. On the previous order, we have specifically mentioned that the Land Council for the state has to obtain instruction whether the appellant intends to proceed with the jail criminal appeal or not in view of the order passed by the Government of Odisha Law Department in releasing him prematurely. Therefore, we think it proper to give some more time to the Land State Council to find out the whereabouts and also to obtain instruction from him as per the order dated 6/10/2023. Srimati Suman Modi, legal counsel for the appellant, is present in court today at top put this matter, give another date after the take up after 4 weeks with a date दे दिया उनको, है ना? ये जो report is taken on record will. Yes.
Obligement.
Yes, Mr. Das.
Hello.
Number 5.
We have mentioned that in the order dated 3/10/2023 that after on perusal of the status report, we are not satisfied with the manner in which the investigation has been conducted, and taking into account the age of the victim at the time of occurrence to be only 14 years, and even though 2.5 years have passed, we directed the Superintendent of Police Jagatsinghpur to appoint a police officer in the rank of DSP to investigate into the matter and carry out a detailed investigation to trace out the victim. Now, anybody?
Madam is appointed as the AIO of the case, madam.
Sarojini Singh. No, what you have elicited is that what the other IO that he has done, what you have done after you are engaged, when you are engaged as the investigating officer of this case, the date. ଆମର ଏ ଅର୍ଡରଟା 3/10 ରେ ଆପଣଙ୍କୁ କେବେ କୁହାଗଲା ଇନଭେଷ୍ଟିଗେସନ? ପ୍ଲିଜ ୟୁଜ ଦି ମାଇକ୍ ପ୍ରପରଲି। ହଁ,
ସପ୍ତାହ ପୂର୍ବ ଦିନ 4
ତାରିଖ ଦିନ। Alright. So let us say 4/10/2023 and we are now on 31/10/2023. So when you are submitting the status report, you are to reflect what you have done after assuming the charge of investigation, not what your predecessor has done. So ଆପଣଙ୍କର entire report ଆମେ ଯାହା ଦେଖୁଛୁ ଯେ
Repetition.
ଏଇଟା ଏଇ ସିଏ ଏଇଆ କରିଥିଲେ ଇନଭେଷ୍ଟିଗେସନ କରିଥିଲେ ଆପଣ କଣ କରିଛନ୍ତି କଣ ପାଇଁ ତାଙ୍କଠୁ ନିଆ ହେଇଗଲା ଇନଭେଷ୍ଟିଗେସନ ଏବଂ କଣ ପାଇଁ ଦାୟିତ୍ୱ ଦିଆଗଲା ଆପଣଙ୍କୁ କାରଣଟା ହଉଛି ଆମେ ଯାହା ଇନଭେଷ୍ଟିଗେସନ ହେଇଥିଲା we are not satisfied with that, right?
Sir.
It 14 years girl has been kidnapped and for 2.5 years his whereabouts is not known, and so that is why we directed that a responsible police officer to be entrusted with the investigation of the case. Since you have been entrusted with the case of investigation, what you have done? ଆପଣଙ୍କର ରିପୋର୍ଟ ଧରନ୍ତୁ କୁହନ୍ତୁ ଆପଣ କଣ କରିଛନ୍ତି ଆପଣ କଣ ଲେଖିଛନ୍ତି କଣ କରିଛନ୍ତି କୁହନ୍ତୁ 3 ସପ୍ତାହ ହେଲାଣି ଆପଣଙ୍କୁ ଦାୟିତ୍ୱ ଦିଆଗଲାଣି ଆପଣ ନିଜେ କହୁଛନ୍ତି 3 ସପ୍ତାହ ହେଇଗଲାଣି ଏ 3 ସପ୍ତାହ ଭିତରେ ଆପଣ କଣ କରିଛନ୍ତି କୁହନ୍ତୁ ଆପଣଙ୍କର ପ୍ରିଡିସେସର କଥା ଭୁଲି ଯାଆନ୍ତୁ
Sir. Most of us, I have examined the whole close friend of the accused.
where have you written and what you don't say anything which you have not mentioned କଣ କରିଛନ୍ତି କଣ ଲେଖିଛନ୍ତି ଦେଖୁନା
Have you got the case diary?
Sir.
After taking over the charge of investigation you must be maintaining the case diary or not?
Yes, sir.
Have you brought it with you?
The case diary, sir.
କଣ ଆସିଲେ କଣ ପାଇଁ ଆପଣଙ୍କୁ କଣ ଇନଭେଷ୍ଟିଗେସନ କରିଛନ୍ତି ଆପଣ କଣ କରିଛନ୍ତି ଏବଂ ତାର ସପୋର୍ଟିଂ ଡକୁମେଣ୍ଟସ ହଉଛି କେସ୍ ଡାଏରୀ
Sir.
ଆପଣ ଯାହା ଡେ ଟୁ ଡେ ଇନଭେଷ୍ଟିଗେସନ କରିଥିବେ କେସ୍ ଡାଏରୀ ଉଲ୍ଲେଖ କରିଥିବେ ନା ନାହିଁ
Yes, sir.
ତ ସେଇଟା ଯଦି ହେଲେ ସେଇ ବିଷୟରେ ଆପଣ ହାଇଲାଇଟ କରିବାର ଥିଲା ଯେ ମୁଁ ଇନଭେଷ୍ଟିଗେସନର ଦାୟିତ୍ୱ ନେଲା ପରେ ଏଇ ଜିନିଷ ମୁଁ କରିଛି ଏବଂ ଆମେ ପଚାରିଲୁ ଯୋଉ ଯେ କେସ୍ ଡାଏରୀଟା ଦେଖାନ୍ତୁ ଆପଣ ଦେଖେଇଥାନ୍ତେ ଯୋଉଥିରୁ ଜଣା ପଡିଥାନ୍ତା ହ୍ୱାଟ ୟୁ ହାଭ ଡନ୍ ବଟ୍ କିଛି ଲେଖିନାହାନ୍ତି ଆପଣ ଖାଲି ଲେଖିଛନ୍ତି ସେ ପ୍ରିଭିୟସ ଆଇଓ ଏଇଆ କରିଥିଲା ସେ this has been done no clue has been so all these are the past we are not in the past we are in the present ଆପଣ ଖାଲି ଲେଖିଛନ୍ତି as a IO you come to the fifth last 5 lines or 6 lines as IO I have taken sincere step to rescue ଏଟା କଣ ଲେଖିଛନ୍ତି ଆପଣ ହଁ ଟୁ ପରେ rescued ହୁଏ ହଁ in the rank of a DSP sincere step to rescue the victim girl but failed to thrust her out କଣ ତା ମାନେ କଣ
Typing, sir. Trust. Trace.
All right, but how could you place a matter which you have not gone into? After correction, you should have placed it, or you have taken it granted the court.
you are placing a report before the High Court and you are a DSP I have contacted with the cyber cell Jawasimpur time to time to obtain the location and tracking record movement but no information could be obtained several steps have been taken to rescue the victim girl and apprehension of so and so but in spite of our sincere attempt the case could not be detected investigation is on to rescue this is very easy to write all these things very easy sitting at your police station you can write all these things what sincere steps you have taken
Sir, I have conducted raid in the house, probable places, and house of accused.
No.
Where have you mentioned it? Where is the documentary proof to that effect? That you have done this, that you have gone to this place to search the found, you have gone to the relation's house, you have examined this witness. Where is the you have written? Several steps have been taken to rescue the victim girl.
You said that only 3 weeks time, last 3 weeks you have joined. You have taken over the charge of investigation. And your report shows that time to time often location tracking record. How many times you have taken? How can we know unless you reflect it in your CD? Otherwise, this becomes a story. This you can write very well. We are not going to the nicety of your report. We want to see substantially what you have done in your investigation.
Please understand the plight of a parents where their minor daughter is at about 14 years is missing from last 2.5 years. They are not aware whether the victim girl is alive or dead. So you are to take up the matter with that sincerity. ସେ ଆଇଓ କଣ ଧରିକିନି 2.5 ବର୍ଷ ଧରିକିନି କଣ କରିଛି ସେ ପକେଇକିନି ରଖିଛି that doesn't mean they have filed a case. The council is telling that no information, no investigation practically is done. So ଏ ଟାଇପର ଲେଖିଲେ କିଛି ଲାଭ ନାହିଁ. ଆପଣ you give us a detailed report what you have done and also produce the case diary so that we will verify. We should also be satisfied that after taking over the charge of investigation, particularly in view of the rank which you are holding, you are doing something seriously to trace out the victim and also to apprehend the accused. Otherwise, this type of report, if you'll go on producing every month, there is nothing. We'll give some time.
We have to this. There is no.
Yep. For 2 months more time, sir.
Okay, we are granting you time, but prepare a detailed report, make sincere investigation, and also come ready with your case diary for verification of the.
Okay.
Sarojini Singh, DSP, IUCAW, Jagatsinghpur, who has been assigned charge of investigation by the Superintendent of Police Jagatsinghpur, opposite party number 2.
The DSP.
To be as per our order dated 3/10/2023, and the investigating officer is present in court and has submitted the status report, wherein it is mentioned that she had taken sincere step to rescue the victim girl, but failed to trace her out, and she has also contacted with the cyber cell Jagatsinghpur time to time to obtain location and tracking record and movement, but no information could be obtained. And that several steps have been taken to rescue the victim girl and to apprehend the suspect Nirakar Poreda. But in spite of the sincere efforts, the whereabouts of the victim and the accused could not be detected. And the investigation is on to rescue the victim girl and for apprehension of the suspect. The investigating officers, after going through the status report submitted, we are not satisfied with the manner in which the investigation has been carried out as mentioned in the status report, even though has taken over the charge of investigation in the last 3 weeks. The investigating officer request for an adjournment and submitted that we will produce the case diary and all the details of steps which he had taken for locating, for rescue of the victim girl and to arrest the suspect. We have noted down in the order dated 3/10/2023 that the victim girl was the minor daughter of the petitioner, was aged about 14 years at the time of occurrence, and 2.5 years have elapsed since the date of registration of the first information report. And being unsatisfied with the status report furnished by the predecessor, we directed the SP to appoint a police officer in the rank of DSP to investigate the matter and to carry out a detailed investigation to trace out the victim and also the opposite party number 4, Nirakar Poreda, who has been named as an accused in the affair lodged by the petitioner. We hope and trust that the investigating officer appointed by the SP Jagatsinghpur will carry out a thorough investigation into the matter and take every possible steps to rescue the victim and to arrest the accused and apprise this court on the next date regarding the steps taken by her and to produce the case diary, put up this matter on cable of your phone. The 28 तारीख दीपावली पर तो दीपावली में सेटा को दिखाती है करने वाले. So we are keeping it on 28th of November. You are getting almost 1 month time. So come prepared. There is a procedure also. He must be aware about it. So how to trace out and take the permission of publishing the photographs if they gave the consent in the newspapers on the print and electronic media to that somebody, and also find out whether the bank accounts is in operation or not of that accused, whether any relations of the accused is staying outside, and all these things. No, locally you cannot get. They are not staying here. They had gone somewhere. And the main problem is about the age. Now also she is about 16 or something. So free copy of the order be handed over to the land council for the state. Yeah. Okay.
Item 13.
May I please, Lords? My Lord, last order dated 27/9/23.
What is the last order?
27/9/23.
27/9. Is it 119 years or 19 years? Date of birth of the victim is so and so, 119 years tar age kon likhchon.
It is only 119 years now. It is 19 years.
19 वर्ष होता है
19 वर्ष मतलब 19 मतलब 19 years 7 months.
now it's major
So now it is 20, more than 20, right? Madam?
Yes.
What is it? She's the that was it. Don't.
So 6 months have already passed. The victim is major. What the accused was doing, is doing now.
ସେ ଡ୍ରାଇଭରିଂ କରୁଥିଲା
कौन कହୁଛନ୍ତି ड्राइवर
ଡ୍ରାଇଭର
ड्राइवर ସେଇ ଯୋଉ ଗାଡିରେ ତାକୁ ସେ ଝିଅକୁ ନେଇକି ଯାଇଥିଲା ଯୋଉ ଗାଡି ସେ ଡ୍ରାଇଭିଂ କରେ ସେଇ ଗାଡି ନା ଅନ୍ୟ ଗାଡି
ନା ନେଲା ବେଳକୁ ସିଏ କୋଉ ଗାଡିରେ ନେଇନି ତାର ପ୍ରଫେସନ ଥିଲା ସେ ଡ୍ରାଇଭରିଂ କରିବେ
please see that what is been written there
Your report you see.
in a white car he along with the associates 3 to 4 associates in a white car and they threatened against the dire consequence to the swans so ତାଙ୍କର ରିପୋର୍ଟ ହିଁ ହଉଛି ଯେ ହ୍ୱାଇଟ୍ କାର୍ ରେ ହିଁ ଭିକ୍ଟିମ୍ କୁ ନେଇକି ଯାଇଛନ୍ତି
ମୟୂରଭଞ୍ଜ ଏରିଆରେ ତା ସାଙ୍ଗମାନେ ଆସୁଥିଲେ ସେ କାରରେ ତାକୁ ନେଇକି ଯାଇଥିଲେ ବୋଲି ମୁଁ ସେ ରିସେଣ୍ଟଲି ମୁଁ କେସ୍ ଟା ପାଇଛି ଏବେ ଭରବାଲି ଜଷ୍ଟ ମୁଁ ରେକର୍ଡ ଧରିକି ଆସିଛି ରିଟିନ ଅନ୍ ରିଟିନ ରିପୋର୍ଟ ବି କିଛି ହେଇନି ତ ବେଶୀ ଥରୋଲି ଭିତରକୁ ମୁଁ ପଶିନି ଆଉ ମୁଁ ଯେତିକି ବୁଝିଛି ସେ ମୟୂରଭଞ୍ଜ ଏରିଆରୁ ସେମାନେ ତାର ଘର ପିଲାର ଘର ହେଲା ମୟୂରଭଞ୍ଜ ଏରିଆରେ ସେଇଠୁ ତା ସାଙ୍ଗମାନେ କିଛି ଜଣ ଆସୁଥିଲେ ଆଉ ଝିଅକୁ ଏଠୁ ଉଠେଇକି ନେଇଯାଇଛନ୍ତି
no no
ଆଉ ସେ ପିଲାଟା ଝିଅ ପୁଅର ଏବେ ମୁଁ ପୂଜା ଭେକେସନ ସମୟରେ ଏଇ ରେକର୍ଡ ଟା ମତେ ଦେବା ପାଇଁ ଯେତେବେଳେ ଡିସ୍କସନ ହେଇଥିଲା ସେଇ ସମୟ ବେଳକୁ ମୁଁ ମୋର କନଫିଡେନ୍ସିଆଲ ଇନକ୍ୱାରୀରେ ଯେତିକି ମୁଁ ପାଇଥିଲି ସେମାନେ ଖଡଗପୁର ସାଇଡ ରେ ତା ବାପ ଅଛି ସେ ପାଖରେ ଅଛନ୍ତି ବୋଲିକି ମୁଁ ଶୁଣିଥିଲି ପ୍ରପର ଲୋକେସନ କିଛି ପାଇପାରିନଥିଲି ଆଉ ସେ ବିଷୟରେ ଯିବା ଲାଗି ମୁଁ ଏସପି ମ୍ୟାମ୍ କୁ ବି ରିକ୍ୱେଷ୍ଟ କରିଥିଲି କିନ୍ତୁ ସେ କହିଲେ ପୂଜା ଭେକେସନ ପରେ ଯାଇକି ଯାହା ହେଇପାରିବ ଆଉ
ନାଇଁ
proceed କରିବି।
କିଛି ସିଡିଆର ଏଣ୍ଟ୍ରି ତାଙ୍କ ଘରକୁ ଯୋଉ ଫୋନ ଆସୁଛି ମାନେ ପୁଅ ପାଖକୁ କିଏ ଫୋନ କରୁଛି କି ନାହିଁ ଝିଅର ସାଙ୍ଗ ମାନଙ୍କର ପାଖକୁ ସିଏ କଣ୍ଟାକ୍ଟ ରଖୁଛି କି ନାହିଁ ସେ ଝିଅ କାରଣ ସେ ମେଜର ହେଇଗଲାଣି ତ ବାହାଘରର ବର୍ତ୍ତମାନ କିଛି ଅସୁବିଧା ନାହିଁ ଇନ୍ ସ୍ପାଇଟ୍ ଅଫ ଦ୍ୟାଟ ହ୍ୱାଇ ଦେ ଆର୍ ହାଇଡିଂ ମାନେ ଯଦି ଆପଣଙ୍କର କେସ୍ ହଉଛି ଯେ ବର୍ତ୍ତମାନ ପର୍ଯ୍ୟନ୍ତ କାରଣ
ପୁଅର ବାପ ସେପଟେ ବାହାରେ ରହୁଛି ତ ପୁଅର ରିଲେଟିଭ ସେମାନେ କିଛି କହିପାରୁଛନ୍ତି ଯେ ସେ ବାହାରକୁ ପଳେଇଛନ୍ତି ବଟ ଝିଅ ଘରରେ କାହାରି ସହିତ ଝିଅର କିଛି କଣ୍ଟାକ୍ଟ ହଉନି
ଝିଅ ତାର ସାଙ୍ଗ ମାନଙ୍କୁ ବି କିଛି କଣ୍ଟାକ୍ଟ ହଉନି ଆପଣ ତାର ସାଙ୍ଗମାନେ କିଏ ଏସବୁ ବିଷୟରେ ଜାଣିବାକୁ ଚେଷ୍ଟା କରିକି ତାଙ୍କୁ ମିଟ୍ କଲେଣି
ଆଜ୍ଞା ସାର୍ ମୁଁ ଯାଇଥିଲି କାଲି ଯେତେବେଳେ ମତେ କହିଲେ ଦୁଇଟା କେସ୍ ତମକୁ
ଝିଅର କୌଣସି ମୋବାଇଲ ୟୁଜ କରୁଥିଲା ତାର ପର୍ସନାଲ କିଛି ମୋବାଇଲ ଫୋନ ଅଛି କି
ନା ସେ କିଛି ମୋବାଇଲ
ନାହିଁ ପୁଅର ମୋବାଇଲ ନମ୍ବର ଆସର୍ଟେନ କଲେଣି
ପୁଅ ବି ଯୋଉ ନମ୍ବରରେ କଥା ହଉଥିଲା ସେଟା ସୁଇଚ ଅଫ୍ ଅଛି ଏବେ କୋଉ ନମ୍ବର ତାର କଣ୍ଟିନ୍ୟୁ କରୁଥିବ ମିଳିପାରିନି ପ୍ରୋସେସ ଚାଲିଛି ସାର୍
ଆଚ୍ଛା ପୁଅର ରିଲେସନ ମାନେ ଯଦି ବାହାରେ ରହୁଛନ୍ତି and you are you have already sought permission of your SP ତେଣୁ ସେ ଇଏରେ ପ୍ରୋସିଡ୍ କରନ୍ତୁ ଆପଣଙ୍କର ରିଲେଟିଭସ୍ ହାଉସ୍ ଯୋଉଠି ଆପଣ ଖବର ଆସୁଛି ଯେ ହୁଏତ ସେଇଠି ଥାଇପାରନ୍ତି ଟ୍ରାଏ ଟୁ ଫାଇଣ୍ଡ ଆଉଟ୍
So please ଚେଷ୍ଟା କରୁଛି sir.
So ଝିଅର ଘର ତରଫରୁ କିଛି ଆପତ୍ତି ଅଛି କି ସେ ପୁଅକୁ ବାହା ହେଲେ? ଝିଅର ମାନେ what is about you?
accused person already married.
କିଏ?
ସେ ପିଲା ଯିଏ ଯେ ଝିଅକୁ ନେଇକି ଯାଇଛି।
ଓହୋ ଆଚ୍ଛା।
ଆଗରୁ ଗୋଟେ ମ୍ୟାରେଜ କରିଥିଲା।
Oh,
ତାର
I see.
3ଟା ପିଲା ଅଛନ୍ତି।
Just a minute, let us see that.
ସେ affidavit ରେ
The accused is a married person. You mean to say that the accused is a married person?
No, no.
Ah,
Ah,
that is
that
different.
is-
That is how this is more serious.
ଯେ ସେମାନେ ଯୋଉ 3-4 ଜଣ ସାଙ୍ଗ ହେଇକିନି ଯାଇଥିଲେ, how do you say that ସିଏ ସେଇ ତାରି ସାଙ୍ଗରେ ଇଏ ଅଛି ବା ଅନ୍ୟ ଯୋଉ ତା ସାଙ୍ଗମାନଙ୍କ ସାଙ୍ଗରେ କାହା ସାଙ୍ଗରେ ଆପଣ ଯୋଉ ସନ୍ଦେହ କରୁଛନ୍ତି
ଆଜ୍ଞା।
ତାର ଆଫେୟାର ବିଷୟରେ ଏ ବିଷୟରେ କିଏ କୋଉଠୁ ପାଇଁ ଜାଣିଲେ ଆପଣ?
ମାନେ ଏମାନେ ଶୁଣିଲେ ଯେ ଆଙ୍କ ଘର ଲୋକ ଯେ ଏଇ ପିଲା ଆସିକିରି ତାକୁ ନେଇଯାଇଛି।
ଯେ ସେମାନେ ଯୋଉ 3-4 ଜଣ ହେଲେ ଯେ ଏଇ ଆକ୍ୟୁଜ ସାଙ୍ଗରେ ତାର ଆଫେୟାର ଥିଲା, ଯୋଉ ଯିଏ କି ମ୍ୟାରିଡ ପର୍ସନ
ଆଜ୍ଞା।
ବା ତା ସାଙ୍ଗମାନଙ୍କ ସାଙ୍ଗରେ ନଥିଲା ବୋଲି କେମିତି ଆପଣ ସିଓର ହେଲେ? ଏସବୁ ବିଷୟରେ କେମିତି ଜାଣିଲେ?
ଇନଷ୍ଟ୍ରକ୍ସନ
What you have got it? ମାନେ ଏଇ ଯୋଉ ମ୍ୟାରିଡ ପର୍ସନ, ଓବିୟସଲି ସପୋଜ ସିଏ ଜାଣିଛି ଯେ ଇଏ ମ୍ୟାରିଡ ପର୍ସନ, ତାର ପିଲାପିଲି ଅଛନ୍ତି,
ସାର୍
ତେଣୁ
ଭିକ୍ଟିମ ଜାଣିନାହିଁ।
ହଁ
ଭିକ୍ଟିମ ଜାଣିନଥିଲା, ସେଇଥିଲାଗି ସେ ପଳେଇଛି।
ଓହୋ।
ପଛରେ ସେ ଜାଣିଛି। ଏସବୁ ଇନଭେଷ୍ଟିଗେସନରେ ହେଇଛି।
So you have not reached the family of the accused.
Where is the house of the accused? ଏମାନଙ୍କ ଘର କୋଉଠି? ଏଇ ଯୋଉ ଲୋକଟାର ଯିଏ ମ୍ୟାରିଡ ପର୍ସନ ଯାହା କହୁଛନ୍ତି ତାଙ୍କ
ମୟୂରଭଞ୍ଜ ବୈଶିଙ୍ଗା ଥାନା ଅଣ୍ଡରରେ।
All right.
ଯାଇଥିଲେ କି ଯୋଉ ମୟୂରଭଞ୍ଜ ଯିବା ପାଇଁ ଆପଣଙ୍କର ଏସପିଙ୍କର ପରମିଶନ ଦରକାର?
ହଁ ସାର୍।
You have this permission. It's not
ମୟୂରଭଞ୍ଜ
very
ଯାଇନି,
important.
ଓନ୍ଲି ଚାନ୍ଦିପୁର ଯାଇକି ମୁଁ କାଲି ମତେ ରେକର୍ଡଟା ତମେ ଏଟା ନବ ଆଉ କେସ୍ ଇନଭେଷ୍ଟିଗେସନ ତମେ
So
କରିବା
you
କହିଲେ।
want some further time?
ସାର୍
Right. Inspector Kamalini Thandi in IUCAW Baleshwar is present and she has submitted a status report as per the order dated so and so, from which it reveals that she has searched different places, that is the houses of the relatives of the informant and the accused, like to trace out the victim and also but the victim could not be traced, and from the CDR analysis no clue could be established regarding the present whereabouts of the victim and the accused. The investigating officer submitted that appeared in person and submitted that since recently she has taken over the investigation of the case, some more time may be granted to him to make thorough investigation and to visit different places. That is the possible hideouts of the victim and the accused, and to furnish the status report indicating the further progress made. The case is posted to 28th from November 2023. The IO shall remain present with the case diary and submit the status report showing the progress made in the meantime. Pre-copy of the order be handed over to the Land and Council for the state. Yes.
Item 14
Order of the petitioner missing since 1923. Order dated 4/10/23, they were to ask for status report.
Petitioner's minor daughter has been kidnapped, right?
Right.
Name of the accused is also indicated in the affair.
Chitu
Litu Muhammad.
Singpuri.
So as on the date of occurrence, he was 17 years, 5 months and 8 days.
Yes.
Yes, Mr. IAC, please come. So you have mentioned in detail what steps have been taken. So you are still unable to find out the whereabouts of the accused. So any places you have visited, the house of the accused, any relative's house, anything like the investigating officer, has he gone there?
Sir,
अच्छा कोठी हमारी ओडिशा भीतर ना बाहर को जाए
sir, Manikogoda under Bolgod PS,
ओके
Jatni,
से कौन कार
Jatni
रिलेटिव्स का हाउस अक्यूज्ड रिलेटेड सेठी कौन मिलला इंफॉर्मेशन मिस्टर आईओ प्लीज कम अपन भी छिड़ा हुंजो हां प्लीज कम टू द माइक
ମାଣିକାଗଡା ଆମର ଭିକ୍ଟିମ ର ରିଲେଟିଭ କୁ ନେଇକି ଯାଇଥିଲୁ, ତାର ବାପାଙ୍କୁ ନେଇକି ଯାଇଥିଲୁ, ତାଙ୍କ ଘର ଯାଇକି ଡାଇରେକ୍ଟ
कहा घर गले जो माणिकगड़ा कहउछन्ती विक्टिम रो रिलेटिव ना अक्यूज्ड रिलेटिव
सर अक्यूज रिलेटिव
अक्यूज्ड रिलेटिव अक्यूज्ड रिलेटिव को विक्टिम घर लोक नेकी जाइथिले सेमान केम जानले इटा अक्यूज्ड रिलेटिव
ନା ସେମାନେ ଜାଣିଲେନି, ସେମାନେ ଆମ ସାଙ୍ଗରେ ଆମେ ପ୍ରପର ଯାଉଛୁ ବୋଲିକି ତେଣୁ ଆମ ସାଙ୍ଗରେ ଯାଇଥିଲେ ସେ ଗାଁଟାକୁ। ସେ ଗାଁଟା ତାର ହଉଛି ମାମୁଁ ଘର, ଆକ୍ୟୁଜ ର ମାମୁଁ ଘର। ତେଣୁ ମାମୁଁ ଘରକୁ ଯୋଉ ଯାଇଥିଲୁ ତାଙ୍କୁ ନେଇକି ଯାଇଥିଲୁ, ସେ ଘରଟା ପୁରା ତାଙ୍କର ସେଠି ଆମେ ସର୍ଚ୍ଚ କଲୁ, ତାଙ୍କ ପ୍ରେଜେନ୍ସ ରେ ସର୍ଚ୍ଚ କଲୁ, କିନ୍ତୁ ସେଠି ତାଙ୍କୁ ପାଇଲୁ ନାହିଁ।
लोकालिटी रे फोटो देखैथिले
ସାର୍
जे एमती पुओ झियो एमती फोटो तो थिला ना अपन पारे
ସାର୍
जे एमती पुओ झियो टिके आस्थिले कि नाही रहउथिले कि नाही
ସାର୍ ଝିଅର ଫଟୋ ଥିଲା ଆମ ପାଖେ,
हां
ଝିଅର ଫଟୋ ସାର୍ ଦେଖେଇଥିଲୁ ସାର୍।
पुओ फोटो नाही
ପୁଅ ଫଟୋ ସାର୍ ପାଇପାରିନୁ ସାର୍।
पुओ फोटो एपर्यंत पाई ना कोन पई व्हाट इज द डिफिकल्टी इन प्रोक्यूरिंग Where is the house of the accused?
Bira Singhpur.
Huh?
Bira Singhpur.
In Narsinghpur area.
So,
Narsinghpur.
ତା ଘରକୁ ଯାଇନାହାନ୍ତି ଆପଣ
Sir,
ଟୋଟାଲ?
ଯାଇଛି।
ତା ଘରେ ତାର ଫଟୋ ନାହିଁ ଟୋଟାଲ?
ନାଇଁ sir।
କଣ କହୁଛନ୍ତି ଆପଣ? What is the age of the accused?
Sir, 21 ବର୍ଷ। 21 ବର୍ଷ।
21 ବର୍ଷ ହେଲାଣି, ତାର କୌଣସି ଫଟୋ ଆପଣ ତାଙ୍କର ପାଇଲେନି? ତାର ଫ୍ରେଣ୍ଡ ସର୍କଲ ପାଖରେ ତା ଘରୁ କୌଣସି ଫଟୋ ପାଇଲେନି? ଗୋଟେ ଲୋକାଲିଟି କି ଯେତେବେଳେ ଯାଉଛନ୍ତି ଆପଣ ଦି ଜଣଙ୍କ ଫଟୋ ହେଇଗଲେ ବିଭିନ୍ନ ସେଠି ପାଖରେ ସେ ଦୋକାନ ଫୋକାନ ଏଗୁଡାକ ସବୁ ପଚାରିଲେ ସେମାନେ କହିପାରିବେ ଯେ ଏମିତିଆ ପିଲା ଆସିଥିଲେ କି ନାହିଁ। ଆପଣ ତ ଫଟୋ ନେବେନି, ସେ କେମିତି ଜାଣିବେ? ଆପଣ ଯଦି ନାଁ ପଚାରିବେ ସେ କଣ ନାଁ ଜାଣିଥିବେ? ସେ କୋଉଠି ପଢୁଥିଲା କୋଉଠି?
ଝିଅ ପଢୁଥିଲା ନରସିଂହପୁର କଲେଜ।
ଆଉ ପୁଅ?
ପୁଅ ସାର୍ ସେ ଡ୍ରାଇଭିଂ କରେ।
ଡ୍ରାଇଭିଂ କରିଦେଲେ ଡ୍ରାଇଭିଂ ଲାଇସେନ୍ସ ଥିବ ନା?
Did you inquire it from RTO?
ନା sir।
So no step has been taken by
investigation
absolutely.
କରୁଛନ୍ତି।
Just an I was to give a report to the court. Why are you coming this way, sir?
Is it believable that a person would be 21 years and he has
Yeah,
never
no.
taken any photographs?
In these
Particularly
days,
when he is in a driving license thibo, ye thibo, ତାକୁ ଆପଣ driving license obviously photo available ଥିବ, but it is pointed out to you. ନା ଏଗୁଡାକ ସବୁ ଆପଣଙ୍କୁ କହିବାକୁ ପଡିବ କେମିତି? ଆଉ ଫଟୋଟା ନଥିଲେ ଆପଣ ହ୍ୟାଣ୍ଡିକ୍ୟାପ୍ଟ ହେଇଯିବେନି? ତାକୁ ଗୋଟେ ଯୋଉ ଲୋକେସନ କୁ ଯିବେ ଆପଣ ଯଦି ପଚାରିବେ ତାର ଇଏ ଯେ ଏମିତିଆ ପିଲାକୁ ଦେଖିଛନ୍ତି ନାହିଁ, କେମିତି ଇଏ କରିବେ? ତାର ଯୋଉ ଫ୍ରେଣ୍ଡ ସର୍କଲ ଥିବେ, ଆକ୍ୟୁଜ ର କେହି ଫ୍ରେଣ୍ଡ ଥିବେ ନା ନାହିଁ? ତ ଫ୍ରେଣ୍ଡ ଥିଲେ ଫ୍ରେଣ୍ଡଙ୍କ ସାଙ୍ଗରେ ଫଟୋ ଥିବ, ଉଠେଇଥିବେ, ତାଙ୍କୁ ପଚାରି ନାହାନ୍ତି? ପଚାରିଥିଲେ? କାହା ସାଙ୍ଗରେ ସେ ଫଟୋ ଉଠେଇନି କେବେ?
You are satisfied by yourself. Besides the fact that you are the investigating officer with your age and experience, are you satisfied what you are stating? That yes, there could not be any photograph? Why are you giving such statement?
ଜଣଙ୍କର ରିଲେଟିଭ ଘରକୁ ଗଲେ ତାଙ୍କ ରିଲେଟିଭ ହୁଏତ ମନା କରିପାରନ୍ତି ଯେ ନାଇଁ ଆମ ଘରକୁ ଆସିନି, ସେଫ୍ ସାଇଡ ରହିବା ପାଇଁ କହନ୍ତି। ତାଙ୍କ ଘରେ ହୁଏତ ସେମାନେ ରଖି ନ ପାରନ୍ତି, ହେଲା, ଯେ ନାଇଁ ତୁ ଆସିକି ଆମ ଘରେ ରହିଲେ ଏଠି ପୋଲିସ ଆସିବାର ଭୟ ଅଛି, ତତେ ଆମେ ରଖିବୁନି। ବଟ୍ ଆରେଞ୍ଜମେଣ୍ଟ ହୁଏତ କରିଦେଇ ପାରନ୍ତି ଆଉ କାହା ଘରେ ଯାଇ ରଖିବା ପାଇଁ। ସେ ଲୋକାଲିଟିରେ ସେମାନେ ବୁଲୁଥିବେ କି କଣ ହେଇଥିବେ କି କିଏ ଦେଖିଥିବ, ସେ ବିଷୟରେ ଜାଣିବା ପାଇଁ ଫଟୋଗ୍ରାଫ ଟା ନିହାତି ଦରକାର। ଆଉ ଫଟୋଗ୍ରାଫ ଟା ଆପଣ ଯଦି ନ ଆଣିବେ, ଭିକ୍ଟିମ ର ଫଟୋଗ୍ରାଫ ଧରି ଦେଲେ କଣ ହବ? That boy is an unmarried or married person? Unmarried. ସେ ରିଲିଜିୟନ ପ୍ରୋବ୍ଲେମ ଅଛି ସବୁ ଆପଣ ଜାଣୁଛନ୍ତି। ଆଉ ସେ ତାର there are different ways of, ସେ ତାର ସାଙ୍ଗ କେହି ବାହା ହେଇନାହାନ୍ତି? ସାଙ୍ଗ ବାହାଘରରେ ଯାଇନଥିବ ବରଯାତ୍ରୀ? କୋଉଠି ରିସେପସନ ଆଟେଣ୍ଡ କରିନଥିବ? ଚେଷ୍ଟା କଲେ ସବୁ ଜିନିଷ ପାଇପାରିବେ। ଫଟୋଗ୍ରାଫ ଗୋଟେ କଣ କେମିତି ପାଇଲେନି? ଗୋଟେ 21 ବର୍ଷ ପିଲା ହେଲାଣି। Yes, Mr. IIC.
Sir.
We are still
We have to, there is no one.
So we are giving some more time, but guide him properly so that some fruitful result would come out. The way things are going on, we are not satisfied with.
See, ultimately tracing the victim is not important. Important is your process.
ଆପଣ ଚେଷ୍ଟା ଯଦି ଠିକ ଭାବରେ କରିବେ, ହଁ, ଯୋଉ ଜିନିଷ ଗୁଡାକ ଆପଣଙ୍କୁ ହର୍ଡଲ କରୁଛି ବୋଲି ଭାବୁଛି ସେଗୁଡାକ ହୁଏତ ହେଇନଥାନ୍ତା। What is the name of the investigating officer? You collect the names of both of them. IAC's name and so and so are present as per the order dated so and so. The IAC Narsinghpur police station has submitted the status report, wherein various steps taken to trace out the victim and also to apprehend the accused has been highlighted. During interaction with the investigating officer, it is told, it was to us that the photograph of the accused, who is a driver and aged about 21 years, has not been collected. We are surprised by such a statement made that the investigating officer is unable to collect the photograph of the accused, which would have helped him in tracing out the accused and the victim if they were at all hiding at any places in relatives' house after ascertaining the same from their locality. The investigating officer, so also the IAC, assured that investigation will be done in some further time is required. Investigation will be done in a serious manner to trace out the victim and the accused. The status report is taken on record. Matter will be listed on 28th of November 2023. The investigating officers will remain present that day with the up-to-date case diary and apprise this court about the development made in the meantime. Free copy of the order be handed over to the Land Council for the state. Yes, come on 28th of November 2023. Yes, next case.
Item 17.
My lord, your lordship's order dated 4/10/2023.
केबे इन्वेस्टिगेशन आपण टेक ओवर कले?
सर दुईटा रेकर्ड काली पाइछि सर
ओ दीटा
विजिलेंस एवार्डेज
ये जो आगोटा जो मैडम को जो ये थिला से टाइप रो ऑर्डर को देखिन सेम डेट रखिले 28 तारिख हो जाना हैला
30 तारिख
गोटे आरटा 28 तारिख रो इतना ये केड़ा केते नंबर आइटम थिला
5
हां फिफ्थ आइटम नंबर 5 ना 9 5 में 13 item 13 हैला item 13 ने same madam is there, so he wants yesterday it was charge was handover likhiwe specifically हैला and he wants to some more time बाकी से later लिखिम रखी देबे same day 28th November 2020. This case is also posted to that day. All right.
थैंक यू
Pardon to make a mention.
Mileage may be
Over
permitted.
57,380. The co-accused, your lordship, granted bail to one of the co-accused. In the present application, the order has been passed that since the present petitioner has been granted bail in that bail application, this bail application has been dismissed. In fact, he was not granted bail. I filed an IA for recall of the order. He is custody since month of February.
Pardon to mention, your lordship, my lord, jail criminal appeal, offense under section 323, 7 months imprisonment.
Modification of the your lordship granted bail on 19/10/2023. In the order, it has been 22 has been mentioned.
Okay.
Could not be released on bail.
Vigilance case, my lord, conviction matter, 3 years only.
7 months.
Mileage may be permitted to make a mention election.
320 offense 323, your lordship, 7 months conviction.
modification of order 16/10 ରେ order ହେଇଥିଲା କେବଳ IA number ଟା ଛାଡି ଦେଇଛନ୍ତି IA number
Tied up bail matter.
let it come tomorrow
Yes, yes, you will come.
Checking the discharge petition and signature, but let's see next day in the lower court it's
Give it.
Mileage may mention election petition number 6 of 2019. As per your lordship's order dated order number 150, the opposite party was supposed to serve the evidence affidavits of 2 more witnesses, the last witnesses in the case, my lord. As per my instruction, my lord, only one, the evidence affidavit of Miss Sophia Firdaus has been served on us, but of one Shakil Khan has not been served, my lord. My lords, the evidence affidavits were to be submitted by 29th, my lords, and tomorrow is the date of.
No, it's all right, but the council is not there. What can be done?
My lords, we had informed, and they.
It's not. On
Pardon to mention, my lord.
Hello, my lord. We want to examine only Sophia Firdaus.
Okay.
We will not examine Shakil Ahmad.
All right. That is the doubt. See, they are having the mind. So, okay. You
They
produce
have got it confirmed to us.
Okay.
There was no necessity for them to.
All right. So, okay.
Pardon to mention, my lord, tied up bail matters, my lord, continue listed. List.
Okay.
Criminal revision, admission matter. Petitioner challenge the order of Session Judge Koraputu. NBW was issued prosecution in a lower court, prosecution file petition.
Revision assignment. Okay. Give it. Yes.
Supplementary list, item number 1.
So grant the extension time sought for. Yes, next.
Item number 2.
2 same extension is allowed. Then
item number 3.
The 2022 home. So 3 ta कुछ code out कर देंगे ना. तो दीटा जगह ऊपर अच्छी टॉप रे ना आई रहा ठीक है शी गुट्टे का बड़ा अच्छा ना. Today is 31st 10/20/23. Yeah. Yes.
Item number 4.
May 498/506, more than 2 months in custody.
Surrender certificate.
I have not availed the interim bail because I received the copy in late, and after due to vacation, I am not availed the interim bail, my lord, granted by lordship.
Just.
I am in custody since 29/8/2023. For DP Act is also not there.
Just.
My lord.
Okay, notice sufficient.
My lord, it served on 18/10/2020.
So, he's in custody since 29/8/2023.
My lord.
What are the offenses under which charge sheet submitted?
Yes, my lord.
What are the offenses?
498A,
Yes.
294,
Yes.
323,
Yeah.
506
Hmm.
by 34 of the IPC, and 31R, 31S, and 32VA of the SC/ST Act.
31R S 32
32VA.
VA.
My lord.
So, what is the relationship between this
I am the
petitioner?
husband, my lord.
Husband. Yes, Mr. Tripathi. Are the learned counsel for the appellant, learned counsel for the state. Learned counsel for the state submitted that notice on the informant has been made sufficient to stop non-appears for the informant. Learned counsel for the appellant submits that in spite of the order dated 17/10/2023, the petitioner has not availed the interim bail order and is still in custody since 29/8/2023. Charge sheet has been submitted under section 498A, 294, 323, 506 by 34 of the Indian Penal Code and section 31 RS and 32VA of the SC/ST. And the petitioner is the husband of the informant, and on account of matrimonial dispute between the party, the case has been foisted. Therefore, bail application may be favorably considered. Learned counsel for the state oppose the prayer for bail, considering the submission nature of accusation against the petitioner, period of detention of the petitioner in judicial custody, relationship between the appellant and the informant. I'm inclined to release the petitioner on bail allowed. Dispose of. खाली को जाइन जाइतला 66 ରୁ start हो. Oh. Then you call the Passover matters. What is the first Passover matter? 31. Adre, display board. 30.
Passover item number 30.
Please, Your Lordship.
Yeah.
But I have filed the IA for condonation of delay. That IA was called for.
Asilagi. Thanks. Interim application was, he said that he has filed it.
I had also served a copy of the Xerox.
Who is that another?
My lord?
Who is that another? That state of Orissa is one opposite party. Who is
Yes,
that
my lord.
another?
The another is, my lord, the opposite party number 2, who is the informant in the court below.
Okay.
The notice to be go.
Okay.
Sangeeta Naik.
IA number 2596 of 2023. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 484 days in filing this CRLA. Issue notice and the question of limitation. IA copy देना थी आपको?
खाली limitation act कर देगी.
हाँ सेटा मैं appeal memo भी दे दूँ तो let the
ना condonation of delay देना.
how
खाली section 5 limitation act देते.
सेगुड़ा तो condonation of delay.
The condonation of delay.
Let a copy of the delay condonation application be served on the learned counsel for the state. Requisites for issuance of notice on the opposite respondent number 2 be filed by tomorrow or day after tomorrow.
Well, it's by day after tomorrow.
By day after tomorrow. Is this matter immediately after the notice on the respondent number 2 is made sufficient for consideration of the application? Yes.
Well, I've already served the copy.
Yes.
No, it's all right. Copy served in court, for example. IS.
Wait for me.
Item number 37.
I'm saying, okay.
କାଲି ଥିଲେ ଯେତେବେଳେ ଡକା ହେଇଥିଲା କହିଥିଲେ non appears କରି adjourn କରିଦିଅ. Yes, next.
Item number 45.
Please, my lords. My lords, on
Yes.
Mother's surgery, wife's surgery, my lord. Instruction was sought for by the state, my lord.
Okay, you made a submission and there is also averment that your wife is suffering from liver problem and it requires surgery.
My lord.
What is your instruction?
Lords, we've sent a letter on 1910, Lordship, but we're yet to
Not
receive the
received. We are granting you for the time till 6th November, get it.
Lordship.
The IN number 1482 of 2023, Land Council for the state submitted that as per the order dated 18/10/2023. Instruction has already been sought for from the concerned police station regarding the element of the wife of the petitioner number 2, na?
My lord.
Petitioner number 2, Shyamdev Kumar, but it is still awaited and the matter may be taken up next week. List this matter on 6th November 2020.
More time,
because both the accused persons are from Bihar, your lordship.
My lord, already 3 months time they are taken, my lord. 3 months. Can it
କେବେ order ହେଇଥିଲା କି ପ୍ରଥମ ଥର ପାଇଁ?
ପ୍ରଥମ ଥର that 2 ମାସ ତଳେ, my lord. ତାପରେ ଦିଥର ଆସିଲେଣି କେସ୍.
Wait. No, see, order, he is right. The order is dated, actually the first order was passed on 24/7. ऐसा से you have करनथिले as per order dated so and so. से order ta date कर दियंतु 24/7/2023 ହେଲା से So 3 months have already passed. Have you sought for any instruction?
Lordship, we have your lordship.
So it cannot be granted for indefinite period.
Lordship.
So last opportunity is granted to 6th November for the time. Yes. Yes.
Item number 47.
May I please? The present
Item number 53.
ସେ ତା ସାଙ୍ଗରେ ଆସିବ ବୋଲି ଲେଖିଦେବେ 404 will come with 407. Yes.
May I please, Your Lordship? And here Your Lordship, may kindly have a glance to internal page 48, running page 56. Here the appellant has been convicted for the offences under section 307 by 34 of IPC and has been sentenced to undergo RI for 9 years, and subsequently consecutively he has been awarded offence under section 326 by 34, for which he has been directed to undergo imprisonment for 5 years. In total, he has to consecutively. In total, he has to serve 9 years for 307 and 5 years for 326.
Yes, 14 years.
My lord. In the meantime, he is in custody since 26/11/2017, Your Lordship.
Your bail application was earlier rejected.
No, my lord. Your Lordship has dealt with the co-appellant's bail application. That file has also come. It is CRL number 504 of 2022. In respect of Anil alias Biswajit Das.
File conclusion देखिए लो. What is that connected number?
CRLA 504 of 2022.
Name of the appellant?
Anil alias Biswajit Dalasingh Rai. In today's cause list, it is there, my lord, tagged up.
The
sub item. It is there, Achha.
My lord.
504. Okay, just a minute. Your submission was that specific overt has been attributed against this
the
appellant.
Present appellant, my lord.
And except the evidence that that accused accompanied you,
My lord.
there is no other matter. So that was the ground on which the other person was granted bail.
My lord.
Since you are the main person who stated to have assaulted. So,
in fact, in the meantime, I am in custody since 2017, and my lord, the
and what are the injuries sustained by the injured?
my lord, in fact, PW16 is the doctor. And the peculiarity of the case is that the case is of 2009, and thereafter the IO had submitted final report. Subsequently, in the year 2017, again the case was investigation was reopened, and subsequently this appellant and the co-appellant, which your lordship had considered bail application, that they were implicated.
With the doctor?
Doctor PW16.
What injury he noticed?
Chemical burn involving front and back of head, face, neck, chest, both shoulders and upper limbs, your lordship.
She's a lady.
She's a lady.
Oh, minor girl, 18 years, of course. And you have spoiled her life. Her face must have been disfigured, and we bring the present photographs of the victim.
Lordship.
Okay. The Land Council for the state seeks some time to produce the recent photograph of the victim. Put up this matter in the week commencing from 13th November 2023. Yes.
Item number 55.
So the prosecution case is that you are carrying 29 kg of ganja,
Yes, my lord.
right?
Yes, my
And you have been found guilty. How do you overcome section 37?
The judgment, Lokesh Chadha judgment. Lokesh Chadha judgment. 2021 Supreme Court.
His official witnesses, everything has been stated. So unless you
Independent witness not been supported the
not
case, my lord. Not
necessary. Suppose they examine and didn't support also. If the official witnesses
seal is not given. Seal also not given to the independent witness. Seal has to be.
Leave those independent witnesses. The official witnesses have implicated you. That it was from your possession. You are carrying it near the railway station, and they caught you red-handed, and 29 kg of ganja was recovered from the 2 bags you are holding. And
Is the gazetted officer before the gazetted officer or the my executive magistrate has not been. I have not.
Its compliance of 50 is not necessary in a case of this nature. It's when a luggage it was recovered from a bag. 50 compliance is not necessary, but however they have complied. It seems that the option was given to you, and
no personal test have been given by the excise officer.
You see, when you are
when I have been searched, that the duty is to give personal search. Who conducted the search?
Argue those points at the time of trial, final hearing.
My lord, now he is on bail, my lord. No chance of absconding.
He must have been taken into judicial custody after the pronouncement of the judgment.
No, my lord. He is outside. We are from BR. He has gone to BR and thereafter.
After the pronouncement of the judgment, are you in custody or not?
Yes, my lord. Yes, my lord.
Are the learned counsel for the petitioner and counsel for the state? After going through the impugned judgment, hearing the land counsel for both the parties, and in view of the seizure of the commercial quantity of ganja from the possession of the petitioner and bar under section 37 of the NDPS Act, I am not inclined to release the petitioner on bail stands rejected. Petitioner is at liberty to renew the prayer for bail if after undergoing half of the substantive sentence, the appeal is not taken up for hearing. Stay realization of fine.
Item number 67.
Taken up 2 weeks after we'll supply the deposition copy.
The deposition copy has already been supplied.
Who are you? You are appearing?
Second item.
Sub item. CRL 709.
Sub item.
That is Chandan Kumar.
My lord.
You are for the?
Chandan.
Okay. What do you want?
My lord, we have already been sentenced for 10 years rigorous imprisonment with 1 lakh fine in the running page 59 60. My lord, in this matter, section 42 of NDPS Act has not been complied.
No, you are seeking for an adjournment in the first one, and you want to argue the matter today. Okay, the first one you adjourn it on this. That is CRL number 700 of 2023. On the prayer of the land council for the appellant, the case is adjourned to 3 weeks for a question. What date they did? Yes, in 709 of 2023, have you supplied the deposition copy?
My lord.
Yes, argue the matter.
My lord, in this matter, the PW3, who is the IO, has submitted the written information to another who was the IIC in this matter. He submitted the written information to another IIC, in which the section 42 of NDPS Act has not been complied. In this matter, particularly in a deposition, he has stated
The DSP is the superior authority. And on that present day, he was working as an inspector of excise with another IIC, Sushant Kumar Padhi.
But he says that Sushant Kumar Padhi, IIC of Excise, is my superior authority.
My lord, in the deposition, page 8, he has already stated in the above process, DSP is the superior authority of inspector.
Which one?
Page 8 of the deposition, PW3.
PW3.
My lord, page 8.
Page 8, which paragraph?
Second, paragraph 7.
Generally, so and so. This one, so inspector is superior authority. Process so and so. The NDPS Act. Okay, Mr. Tripathi, what is your answer to her submission? The person with to whom he submitted that report is of the same rank. Both are inspector. But what he says that man is 3 years senior to me. Yes. Merely because somebody is 3 years senior in the same rank, he cannot be said to be the superior authority. And he says that, in fact, DSP is my superior authority. So that is what he says, that 42 compliance has not been made. So these aspects will be taken into consideration. That where is the have you brought any decisions that suppose the court finds prima facie while deciding bail that 42 NDPS Act provision has been non-compliant? There has been no compliance, so that would be a ground for grant of bail.
My lord, there is 2.
No, I'm not on the acquittal side. I'm on the bail aspect. This judgment on bail or acquittal?
They're on acquittal.
No. Find out the decision. On bail, at this stage, it can be. All right, take down the land. What is your name?
Monica Samal.
Monica Shamal, Land Counsel, appearing for the appellant. Place the evidence of PW3, the non-liquidative, and contended that there has been non-compliance of Section 42 of the NDPS Act. In this case, which vitiates the judgment and order of conviction, and therefore the same is itself a ground for grant of bail. Submitted that PW3 stated that after noting down the information, reliable information received, he handed over the copy to the IAC of Excise, Sushant Kumar Padhi. The Land Council submits that PW3 himself is the Inspector of Excise, and therefore Sushant Kumar Padhi cannot be said to be the superior authority of PW3. And in fact, in the cross-examination, he has stated that DSP is his superior authority. Land Council submits that as per subsection 2 of section 42 of the NDPS Act, the officer taking down the information in writing under subsection 1 or recording grounds for his belief under the proviso thereto is required to send copy thereof to his immediate official superior within 72 hours. And since the person to whom the information was handed over was of the same rank, merely because he is 3 years senior to PW3 cannot be said to be the superior authority. Land Council for the state, on the other hand, submitted that the submission of the Land Council can be taken care of at the stage of final argument of the appeal, but not at this stage while considering the application for bail. Both the Land and Council want to cite some decisions on this point, whether non-compliance of section 42 of the NDPS Act can be a ground to grant bail to an accused who has been convicted under section 20B2C of the NDPS Act. Is this matter
In that respect, I have a judgment that Lokesh Chadha.
No, today there is no time. I'm just rising, so
Next Monday.
next Monday, all right. You will get ready on within that time, 6th November 2020. You hand over a free copy to the state.
I don't to mention my lord. I don't know 98. Only copy not served, that is the noting order. Already I have served my lord. Last occasion already I have mentioned.
We'll take up this rest of the matter next week.